my final attempt at trying to help you. Police-led theory that I'm the pedophile, where in my investigations, I find out that the pedophiles are actually people employed in services and they're protected. Get this through your stupid, thick head, Robb Ess. Okay? True pedophiles are protected. Pedophiles are never identified to all and sundry by the Police Service of Scotland unless you have got information that can cripple them and they're out to cripple you and completely decimate you and your character in the eyes of everybody else. And you seem to be helping the police with this theory by ignoring me and continuing to ignore me, and it makes me angry. Because the things that you're doing, I gave up Dane 30 years ago, Rob. This idea about all the people coming together and will never ever happen. And there's no requirement for it to be so. One final time, Rob, I'm going to reach out and try and help you. Because I'm angry with the way you've been treated. And if you are truly genuine, and you aren't part of this psychological operation to decimate, discourage, and pervert the course of justice for real Scottish people that are looking for effective remedy, redress and accountability before the courts and how to get them. If you're not part of that operation that makes sure people never gets that, then you'll listen to what I've got to say and you'll do exactly as I'm telling you. It's just a shame that we can't come together as friends. There's an awful lot of history between us that you would choose to deny. Now you're starting to feel the pressures of everything that I know you're about to go through unless you act at once. I am the only man in Scotland that will give you this information. And you need to act on it, Rob. There's no point making videos outside Paisley Sheriff Court about administrative hearings and mens rea and actus rea and how people are doing this and people are doing that. This is futile. It's useless. It's advising no one, it's helping no one, and it certainly isn't helping you. Now I'm going to take you through, right off the top of my head, with no research done, no further investigation by me. I'm an ill guy who's now in a wheelchair, thanks to an eating disorder brought on with the nervousness of what people like yourselves have done to me. Because you're acting in concert with the Police Service of Scotland to procure, to identify, to ridicule people like myself that are absolutely genuine, Rob. Okay? Absolutely genuine. What you must do at once, and I'm not interested in your common law tact. If any of the common law stuff worked, John Smith would be there with your birth certificate, your newfound registration birth certificate, another fiction, another bit of paper, another thing that's created under an act. So we're going to talk about acts and statutes, because this crazy idea that, oh, we didn't go with acts and statutes, we common law is acts and statutes, Rob. It always has been acts and statutes. Everything has been acts and statutes, Rob. So let's not make a mess of this by trying to differentiate between common law and act and statute. If you really want to get into the depth of it, the common law still exists in the format of every single act and statute that's ever been brought upon us. Because that is now the common law. I'm not a man that will stand outside courts talking about sheriffs and all the rest of it, because you've no idea the host of crimes that can actually be placed on top of your head as a result of what you've done. I'm going to help you protect you. I'm going to help you protect your family. I'm going to help you protect the minors in your family from future abuses. I'm going to help you, Rob. And I want to see if you take this help, whether you agree to meet up with me eventually, whether you're genuine, whether you're real, if you take this information and you utilize this information and you act at once, you will win your case. And your case will end up in the European Courts of Community Justice. I don't want to hear any stupid excuses about independence, Scottish sovereigns, Scottish rights, common law. It does not exist. And the reason it doesn't exist is because people like yourself and people like myself cannot get the claim in. And that's why we must come together like you're asking. I'm going to tell you exactly what to do. And you do it today. Do nothing else. And do nothing else until you've done this. Really angry with you. Right, in 2012, right, in Scotland, Rob, we've got the Scotland Act. It was handed down by the UK government in 1998 when we got our devolved powers. Back then, a devolution minute, right, was raised on a 40.2 forum. So you go into the Scottish website, the Scottish ministers, the Scottish government website, you go into the court section, you look for forums, right, and you look for compatibility issue forums. You'll find them numbered 40.2, 40.3, all the way up to 40.9. You download a 40.2 forum and you give notice of intention to raise a compatibility issue in the case reference number. And you send that away today, at once, immediately. Then you're going to take down a 40.9 forum. A 40.9 forum, the way it's written up, doesn't actually reflect the European questions and the European challenges that you need to make to the legal challenge that's came against you. The legal challenge that comes against you is started by a corporation that has no royal prerogative. Okay? The European questions are multiple that need to be asked, so I'm going to be patient to think about this. Maybe take me a wee while, but you need to listen. And you need to be sitting with a pen and a paper just now. What you must do is you're raising European questions, asking whether the Scottish ministers have got the legislative force to bring in the act and the statute that starts off your legal challenge, because you believe it's too far away from the 6 European directives that the Scottish ministers must abide by. You have no power under the Scotland Act to bring out such an act and a statute. The legislative authority of the Scottish ministers is ultra vires. So that's one point that raises a European question. Another European question you want to raise on your action is the Police Service of Scotland, that is now a corporation. Now, way back in, it was 1556, I think, you've got what's called the Oaths Act. Okay? Now, there's been several amendments to this Oaths Act through the years relating to England, but not to Scotland. And what the Oaths Act says, Rob, right, that for anybody acting with a royal prerogative, they must, it's imperative, it cannot be ignored, they must swear an oath that starts off with the first line, I swear by Almighty God. So you move forward to 2013, on 1st April 2013, when the Police Service of Scotland was set up as a corporation, a private company with limited liability. And you look at their oaths. The oath starts with affirm to uphold human rights, and that is it. Because of a failure in that oath to read, I swear by Almighty God, they have no royal prerogative. They have no royal force. The corporation that is known as the Police Service of Scotland is just a corporation. It's a private company. They still have instructions from the Home Office, and that probably be the only defence they've got to this. But when you've got a corporation that is acting ultra vires, they have not sworn an oath of a royal prerogative, then the European question to ask is, has the Scottish ministers got the legislative force to bring about a corporation that isn't acting within the law? And has the Scottish ministers got the legislative force to bring about something like the 2026 plan? No, they've not. They haven't. When you look at the 6 directives, when dealing with the services and the protectional services of the European state, which is the UK, i.e. Scotland, it really is up to the European state to decide what kind of service that's going to be like. However, once they start employing that service as required by law, it must comply with the 6 directives that we're signed up to, and the Police Service of Scotland does not. It doesn't stand a hope in hell, really. So that's 2 points on legislative force and legislative competence as far as the Scottish ministers are concerned. The other European questions that must be asked then relates to the courts. Now, I'm going to go into a bit of legalese here. You probably only appreciate it, but you need it. In 2013, there was new acts and amendments to existing acts dealing with sections 34, 35, 36, 37 of the Scotland Act. I advise you read it. You have got an option under section 34 of the Scotland Act 1998 as amended on the 22nd April 2013, which seen forth the transitional consequential provisions order that was provided for at that time to allow declarator to be asked of the Advocate General. For the Scotland Act, you can make an application to the Advocate General to ask him whether the courts and tribunal services in Scotland are acting ultra vires or whether they're compliant with the law. And under that question, you would mention everything that's happened to you, and you'd mention all the names of the people that's done it, and their private and commercial liability. Hang on, I've been distracted by Kimberly. No, just put it in there. Right. Reference, where was I? Yep, the Scottish ministers. The Scottish ministers are ultimately responsible for the court service. Regardless of the claims that the Scottish ministers will make, oh no, for judicial independence and impartiality and all that, we can't get involved, absolute nonsense. When the whole system's a complete failure and there is no avenue for legal redress, accountability, the Scottish ministers are ultimately responsible for implementing themselves into the case to oversee it by way of ministerial intervention and oversight. They can't deny you, a European citizen, that position. So in a 40.9 form, you've got a couple of questions that raises the question to the legislative competence of the Scottish ministers and asking, are they acting in accordance with the 6 European directives that were signed up to? And we all know that they're not. They haven't. The Police Service of Scotland will crash. The 2026 plan will crash. Your legal challenge will, just on the points of the police. When you come to the court service, what you've got to understand, Rob, is you've got several different services operating there. You've got the Police Service of Scotland, who appear to have the legal qualification to start legal challenges in Scotland. You've got the Lord Advocate's Office. Now, the Lord Advocate's Office is represented by the Crown and Procurator Fiscal Service, a completely different service altogether. Then you've got the Sheriff Court Service, a completely different service altogether. Now, the Procurator Fiscal is the master of the instance. And if you look at the Procurator, if you read anything at all to do with the Procurator Fiscal's Code of Conduct, their Book of Regulations, if you've read any of the stuff that I've read, you would read and you would find out that the Crown and Procurator Fiscal Service is acting ultra vires challenges. And the question there is the Crown and Procurator Fiscal Service a fit body to be bringing legal challenges on behalf of the Lord Advocate's Office, considering the multiple perversions of courses of justices and the attempts to defeat the ends of justices just involved in your one case? And then you would mention all the perversions of justice. You've got the Access to Justice Scotland Act 2008. I'm going to list now a series of acts that you need to read. You need to read the Sheriff Court Scotland Act 1907. It was amended twice through the years. Read the Scotland Act in particular 2, with the Public Bodies Act in all. What the Crown and Procurator Fiscal Service has done is they've decided that there is a case to answer and decided the court service and employ the court service. Therefore, bringing honourable men and women into disrepute at the mere fact of the handling of the case by the Crown and Procurator Fiscal Service and the way you've been treated at courts. So there's really no need for me to go on about how you've been treated and where the contraventions lie. I'm just going to give you the tools in the book that you need. On this 40.9 form that you fill in, after you filled in the 40.2 form, we notice the intention that you intend to raise a compatibility issue in this matter, reference number of your case. On the 40.9 form, you've got 2 or 3 questions there asking about the ministerial competence of the Scottish ministers when bringing in the legislation that they brought. You want to ask, is it too far removed for the 6 directives that were signed up to? And does it provide for safety and security for the citizens of the European state, being the UK, i.e. Scotland? We'll get together on that if you want, and we'll develop that a lot better than what I'm actually suggesting here. The other questions that must be asked on that compatibility issue is the ultra-vireness of the sheriff, right? So we're not dealing with the Sheriff Court Service alone. The Acts Inspire is the Promissory Oaths Act 1868. There's no point in calling out a sheriff on their oath and asking them, are you adhering to your oath or whatever? You know, can I see your oath? That is futile. The fact that the sheriff is sitting on the bench, right, you naturally understand in the law that they are there in mourning for justice, as demonstrated by the cape that they wear. That's what the black cape is. They're in mourning for justice. You're also in mourning for justice. But there's contraventions in the Promissory Oaths Act. And the way you go about that is because you are a lay person before the court, there's no requirement for you to apply yourself by statute regulation that only applies to the authority, being the Law Society that makes up the rules to apply to themselves, unless you got a lawyer. But I'm suggesting that you do the forms in accordance with how a solicitor would do it. But in fact, I'll do it for you. Under sections, there was new sections